All right. Well, good morning, everyone. Welcome to another one of our Google Hangout sessions. We're really happy that you could join us. I am Lior Samfiru, along with my colleague Lumi.
Good morning.
And we're here to talk to you about the things that we know best about. We'll never talk to you about things we don't know. It's a long list. But we'll talk about workplace rights, things that you need to know if you're working, if you have a job, lost your job, if you're employing people. Maybe you're in your car or just got to work wondering about something that happened to you yesterday. Listen to us here on this session. We'll try to inform and advise. These are important things that happen, and you may not be in the situation that we're going to be describing right now, but unfortunately these things do happen. You may find yourself in those situations, and then you'll know. You can always contact us. Go through our website to stlawyers.ca. You can reach myself, Lumi, or any one of our team. Always happy to answer questions, and we strongly believe in keeping people informed and advised with respect to their workplace rights. We're going to talk about an important topic today, and it's a topic that comes up quite often. There's a lot of confusion about it, and we thought it's a good idea to take the next 20 minutes or so to go over it. And that is, what happens if you go off on a medical leave of absence because you can't work, you're sick, and all of a sudden your insurance company, you have a long-term or short-term disability insurer, they won't continue paying you. They'll cut you off, they'll deny you. What does that mean for you with respect to your employer? Do you have to go back to work? What if you can't? What if your employer is now putting pressure on you, saying, well, wait a second, the insurance company is saying you're able to go back to work, so we need you to come back to work. What does that all mean? Now, we did another session here a while ago about medical leaves of absence. So if you want to know generally about what it means to be on a medical leave of absence, how long you can be on a medical leave of absence, you can find the session that we did previously. This is a bit different. We're talking about the intersection between medical leaves and disability coverage. And so if you know someone that's been denied disability, if you've been denied disability by an insurance company, you need to listen to it. We'll talk to you how to deal with those issues, as well as how to deal with your employer in those situations. So to get us started, let's talk just briefly about medical leaves of absence, when you can be off work because of a medical condition. And it's quite a simple scenario. You can be off work for a medical condition if a doctor says you need to be off work. You don't decide that, the individual doesn't decide that, your employer doesn't decide if you can be off work, a doctor has to decide that. So if you go to a doctor and you talk about your situation, you're not feeling well, you have an injury, and a doctor says you can't go to work, as long as the doctor provides a note, a letter, anything in writing to your employer confirming that, your employer has to give you time off work. It's not up to the employer. It doesn't matter if they have a sick day policy or not. By the way, a sick day policy only has to do with whether your employer is going to pay you while you're off. So if, for example, you have 5 paid sick days a year, if you're away for that period of time, your employer has to pay you for those 5 days. But that's very different than being on a medical leave of absence. You can be on a medical leave of absence for a long time, even years. You may not get paid for that period of time, at least not by your employer, but you can still be off. So the fact that you may need to be off work for 2 months, but you have 5 sick days, does not change the fact that you can be off work. So as long as the doctor says you need to be off work, as long as you provide that to your employer, you can be off work. So that's aspect one of the equation that we're going to be talking about today. The second aspect is, what does it mean to qualify for short-term or long-term disability? Many employers have policies for their employees that provide for short-term or long-term disability coverage. The idea being that if an employee has to be off work for an extended period of time, the insurance company, whatever the insurance company that the employer is using, will pay them while they're off, a portion of their salary. Very common. Most employers these days have these policies, usually both. Short-term disability that pays you for the first few months, and long-term disability that pays you thereafter, potentially till the age of 65, if unfortunately you have to be off work that long. That said, as we'll get into it now in a few minutes, many times the insurance company disagrees with the doctor's assessment. Many times the insurance company may feel that the person, in fact, should not qualify for disability or does not have the type of disability that would trigger the policy. So those are very different things. An insurance policy is a defined contract. It stipulates the conditions They have to be met in order to qualify for benefits under the policy. For example, it may exclude a pre-existing condition or other medical conditions. So that's one thing, but that's very, very different than going on a medical leave of absence. So as we're going to be talking about in more detail here, you may well qualify for a medical leave of absence while not qualifying for long-term disability coverage. So I want you throughout this conference that we're having, throughout this little session, to keep those things separate. Being off work because I'm sick and actually getting money from an insurance company because I'm sick are two different things. And what we're going to be talking about is what happens when those things don't line up. Obviously, in an ideal scenario, if we have to be off work, I'm off work, my employer is letting me be off work, and the insurance companies pay me while I'm getting better. That's the ideal scenario. Then I get better, the insurance company stops paying me, and I go back to work. Unfortunately, in many cases, these things don't line up as nicely, and that's what we're going to be talking about today. And we're going to start off with Lumi talking to us in more detail about what happens if you're denied long-term disability, how to deal with that, and what happens in those situations.
Yes, and I would like to start by saying that in some cases, it's the employer who pays the short-term or long-term disability benefits. And so that's why it's very easy for people to confuse a medical leave of absence with an LTD-supported medical leave. And so the fact that the employer is involved in the payment of the benefits does not mean that the two issues are one and the same. And so it's important to keep that distinction in mind. Another thing to keep in mind is that sometimes certain companies don't offer short-term disability, but they offer long-term disability. And so in certain instances, you don't get paid for the first few weeks, or you can apply for EI sick benefits, and then the long-term disability kicks in. Things can get very serious when, for example, you're not well, your doctor says you can't go back, your family physician or your specialist or multiple specialists agree that you're not ready to return to work, but for whatever reason, the long-term disability provider decides that you don't meet the requirements under the policy, and so you're left without benefits. It happens very often that people get cut off benefits. The 2-year mark tends to be, I guess, a milestone for those situations where at the 2-year mark, generally there's a change of definition in disability, and in many instances benefits get cut off. And I should also say that for whatever reason, psychological conditions tend to be treated differently than physical ailments. And so in many instances where the benefits stop, we're dealing with psychological, stress-related, anxiety-related disorders that don't get approved for long-term disability at all, or where the employee gets cut off at the 2-year mark. Again, it happens very often, unfortunately, and we specialize in this area of law. We help people deal with their long-term, sometimes even short-term disability benefits. Don't hesitate to call us if your benefits either don't get approved at all or get cut off at some point during your coverage. It's very important, and there's a lot, like we can help resolve those matters. In general, we call it a disability claim. We deal directly with the LTD provider, and one important thing to keep in mind is that as an insured person, as an employee, you're supposed to comply with the treatment prescribed to you by your doctor. And so if you meet that requirement, and again, your doctor, your family physician, or your specialist say you shouldn't be working, and you get cut off disability benefits or you don't get approved at all, call us.
Yeah, it's a difficult situation. You know, here's how it looks. You're not well. You're under your doctor's care. You still have to pay your bills. You have your mortgage, your other bills. You have to pay your kids' education. Life continues, but now you don't have income. But you say, well, wait a second. At least I have this insurance policy that's there for me. Well, you know, if the insurance policy cuts you off, if they say we're not going to pay you, obviously that makes your life very difficult. The good news is, as Lumi said, in many cases, those matters resolve, and usually resolve fairly quickly. I'm going to be very blunt here. Insurance companies are in the business of trying to avoid paying if they can. They're not ever more generous than they have to be, and usually far less generous than they need to be. So it is quite common for people to get cut off disability before they're ready. So as bad as the situation is that I've just described, that Lumi's just described, you've been cut off disability, let's take it and make it worse. So you're still sick, you're getting better, your insurance company, your long-term disability insurance company cut you off. Now you get a call or a letter from your employer saying, we need you to come back to work right away because you've been cut off disability. And if you don't come back to work, we'll consider you to have resigned. So that's taking a bad situation now, making it much, much worse, because now you're going to be concerned about losing your job and what happens when you get better. Are you going to have any income? Very, very tough situation. So let's talk about that. Let's talk about whether an employer can do that. The short answer is no. An employer cannot and should not do that. And here's why. This goes back to my earlier comment, and that is that being on a medical leave of absence, being away from work because you're sick, is very different than qualifying for disability. You are allowed to be off work sick if a doctor says, your doctor says that you're sick and you cannot work. That's different than qualifying for disability. That may or may not qualify you for disability coverage from an insurance company, but that does qualify you from time off work. Therefore, the fact that an insurance company decides, rightly or wrongly, oftentimes wrongly, to say you don't qualify for disability does not change the fact that you still have the right to be off work sick, that you are not losing your job, that you're not considered to have resigned. It doesn't work that way. Now, if your doctor says you can come back to work and you disagree with the doctor, so you're not going to go back to work, well, at that point, your employer may consider you to have resigned because there's medical information from your doctor that says you can come back to work. But as long as your doctor supports you, as long as your doctor maintains that you cannot work and provides that information to your employer should not be able to say, we don't care about your doctor, we only care about what the insurance company says, we want you to come back to work. It doesn't work that way. As long as you have your doctor's support, you have to provide that information to your employer. You can't assume that your employer should know that, and it's important also to update your employer regularly. So the fact you may have provided a note 6 months ago, and in the meantime, your insurance company says to your employer that you can come back to work, doesn't mean that necessarily that note is still in effect, the one from 6 months ago. You want to, and you should provide a doctor's note. Do you have a comment, Lumi?
I just wanted to add that don't assume that because you provided the medical documentation to your insurance provider,
right,
your employer is in the loop as well. In fact, it's the opposite.
Yes.
The insurance provider is not allowed to share your medical information with your employer. And so, again, keep the two issues separate. Medical leave of absence is up to is between you and your employer, and the LTD coverage is between you and your insurance provider. And so again, the fact that the insurance provider has all your medical documents doesn't mean that the employer has it as well. And so the communication, you need to maintain the communication with your employer open.
Absolutely. And a lot of people are concerned about that. Is my employer going to know what I'm giving my insurance company? Because you're going to provide your insurance company with some detailed information about your diagnosis, your treatment, your condition, and you may not want, for obvious reasons, your employer to know exactly what you're going through. So that's a very important point, because the insurance company is not allowed to share that information with your employer unless you give them explicit written consent. That said, what an insurance company can tell your employer is if you've been approved or denied for benefits. So they will tell them, hey, this employee was denied benefits. And that may immediately make the employer think, well, if they've been denied benefits, that means they can come back to work. So we want them to come back to work. That's why it's so important to update your employer with a doctor's note, with medical information, so that they know you cannot work. And the employer is always going to try to jump on the insurance company's decision as grounds to say you have to come back to work or else. That is wrong. You can be off work even though you don't qualify for disability, or if the insurance company has denied you, whether they denied you correctly or incorrectly. So provide that information, and don't be bullied by it. Don't be concerned about these deadlines that are imposed or by ultimatums. It is an unfortunate situation. A lot of employers may not necessarily understand there's a difference we've been talking about between being on disability, i.e. LTD, and being off work. So you have to keep that in mind, and remember that you still have the right to be off work. Now, that said, despite everything we've just said, that an employer is not allowed to consider you to have resigned or to let you go because you've been denied disability, some employers may still do that. So Lumi's going to talk to us a bit now. What happens if the employer still does something that they're not supposed to do? What does that mean to you, the individual?
So we can't emphasize enough that employers mistakenly believe that the denial of benefits is proof that there is no disability. That's wrong, and so with the separation of the two, again, LTD coverage or disability coverage, and a simple medical or an unsupported or a medical leave that is not supported by benefits, the two are separate. And so just because you can't work, you cannot. It doesn't mean that you can automatically lose your job. Actually, far from it. And so a leave of absence, even without benefits, is basically a form of accommodation, and the employer again can't jump the gun. The employer cannot automatically assume that because you don't have benefits, or you haven't been approved for benefits, you can return to work. And so the duty to accommodate kicks in. The duty to accommodate on the employer's part kicks in. And so again, that accommodation can take many forms. An absence, I guess just a simple absence where you can't work, you keep your employer in up to date with respect to your status. In other cases, you can work, but you can only work modified hours, reduced hours, or you can work modified duties. And so again, that's another form of accommodation. And sometimes, even in the case of a disability, an employee, with the doctor's I guess approval, decides to try a return to work. And in some cases, the return to work is successful. In other cases, it's not. And so a return to work with modified duties or modified hours is another form of accommodation, and the employer is obligated to meaningfully consider those requests and implement accommodation strategies as long as or until the point of our undue hardship is reached. And that undue hardship, I guess, threshold is very difficult to reach. Like it takes a lot for the employer to get to the point of undue hardship. And the larger the employer, the more employees it has, the more resources it has, the more difficult it is to prove that it's reached the point of undue hardship. And the fact that accommodation is costly doesn't absolve the employer from being obligated to accommodate an employee. Do not give in to the pressure of returning to work because an employer asks you to, when your doctor says otherwise. So always go with your doctor's I guess recommendations or orders, and don't feel pressure to return to work prematurely. because that can jeopardize your disability insurance. That can jeopardize your ability to appeal a disability claim. And so do what, like, always follow what your doctor directs you to do. And again, the doctor is the ultimate decision maker, and not the employer or the insurance provider. I'm going to talk briefly about a scenario where very long absence from work can trigger what is called partial, or what we call partial termination or partial severance. And it's the technical term is frustration of contract. And so again, it's triggered in cases where there's a very long absence and where there's a medical note that says that the employee cannot be expected to return to work in the foreseeable future. So those are very strict requirements, and very rarely this frustration of contract situation applies. Generally, we find that employers use frustration of contract too early, prematurely, and open themselves to liability.
Yeah, and it is rare, as Lumi said. The only time your employer can say, well, now I have a job, as Lumi said, is if your absence is very long. Usually we're talking about 2 years or more, and when there's no likelihood of return to work. At that point, they can end the relationship and not have to pay full severance. They would only have to pay a portion or your minimum severance. That said, in all other situations, if your employer is going to treat you as having resigned or let you go because they feel that you were cut off disability and you should have come back to work, in those situations, this would make it a wrongful dismissal. We've already talked, it would be a human rights issue. So not only would you potentially be entitled to severance, you'd be entitled to human rights damages potentially, but also because you're sick, because you may not be able to find a job in the same way as if you were healthy, and that because of that, you actually may be owed enhanced severance, additional severance. So for an employer, letting go an employee that's off on a medical leave of absence is rife with liability. There's a lot of exposure, there's a lot of liability, and it's something that we don't recommend for employers to do unless they don't have a choice, unless they really made sure that they have their I's dotted and T's crossed. So because of that, I highly recommend for employers not to do that, and for employees to understand that you have all kinds of rights and entitlements in those situations. Now, it looks like we've gotten a question. I haven't reviewed it, but I'll ask it now. The question we received is, how long does the employer have, or how long should the employer keep the position open for you to return to work while you're off on a medical leave without disability or without the approval of an insurance company? So how long should the position be kept open? That's a great question, and that touches on this concept of frustration of contract that we talked about, and that is your employer really should be keeping your position open as long as it takes, whether it's a month, 2 months, a year, or longer, as long as you provide them with medical information. There's no time limit. The only time that they don't have to is in this frustration of contract situation, usually when the absence is now 2 years or more, and despite the long absence, the employer, sorry, the doctor, your doctor says it's still not likely that you're going to be coming back to work. If those two conditions are met, long absence and no likelihood of return, at that point the employer may be able to say enough is enough, but still some severance will have to be paid. Okay, so very important to understand. Otherwise, the employer can't say, well, we decided we're only going to keep your job open for a month. It doesn't work that way. There'll be a human rights violation, another liability there for the employer. The follow-up question, actually, no, I think it's the same question. So I think we've answered that. Lumi, any other thoughts here in closing?
No.
So hopefully you found this session interesting. Happy to answer additional questions. You can contact us privately. Just go to our website, stlawyers.ca. We hope you found it interesting. We'll be back in a few weeks with a new session, so watch out for that. And it's cold out there, so hopefully where you are, you're warm. We'll talk to you later, and all the best.
Have a great day.